Hi, estate planning attorney Madison from Estate Law Partners here to give a quick answer to the question of what is probate. Probate is the court-supervised process used to settle an estate when assets can't be directly transferred to a beneficiary or a joint owner of an asset. Since there isn't a built-in answer to the question of who gets the asset, the philosophy is that the court needs to be involved. The person that probates your estate is called the personal representative, also known as the executor. The process begins with giving the original will to the probate court, if there is one, along with an application to the court requesting that the estate be probated and a personal representative be appointed. Notice is given to all interested parties, those named in the will as a beneficiary and those who would receive the property if you died without a will, the heirs at law. A hearing date is set to determine if anyone objects to the personal representative or contents of the will. Assuming there are no objections, notice to creditors is published in the newspaper, and creditors have several months to file a claim against the estate. The PR also files an inventory of the probate assets showing the date of death fair market value. Assets are gathered and an estate checking account is typically opened. Final tax returns are filed, creditors are paid off and/or claims are settled. And once all this is done, the PR then gets to distribute the remaining probate assets either to the heirs at law or in accordance with the terms of your will. The PR then gets receipts and files them with the court along with a request to close the estate, a final accounting, and any necessary documents showing that the taxes have been paid. The court reviews the estate, and if it is satisfied that the process is complete, it will close the estate and discharge the PR. Whew, that was a lot. Typically, probate takes about a year and a half, and it's not surprising when they go longer than that. For estates with few and simple probate assets, the process can be relatively simple and inexpensive, but for larger estates, probate can take a long time and involve large fees. As we talk about in a different video, having a will does not avoid probate. Having a will provides structure and direction for the court and the personal representative. Remember that only a person's probate assets are subject to the probate process. Non-probate assets, such as property held in a trust, life insurance, and retirement accounts with a beneficiary designation, jointly held property with rights of survivorship, all pass automatically without probate. If avoiding probate and not having that long court process is part of your estate planning goals, please reach out to us at Estate Law Partners with any questions.